You would think because it's so powerful of a document that there would be some kind of oversight. But unfortunately, there really is no form of formal oversight over the POAs. So they have their fiduciary duty that they are supposed to act in the best interest of the grantor, but there really isn't any oversight. So it really comes down to perhaps professionals in the senior's life who, might notice some red flags. There is the office of the guardian, the office of the public guardian and trustee, who, if there's a problem or if you suspect abuse, that you can report it to them and they may step in and take over, but that's quite a process. And a complaint has to be made to them in order for them to look into things. They're not generally overseeing all of the power of attorneys that are out there.
Hello, I am Celia Sanka, Executive Director of the DiversityCanada Foundation, the organization that brings you GoldenVoices.com. That's the online portal where seniors gather to focus on issues of importance to seniors. And that's where you'll find the Golden Years Fireside Chat series, where we look at issues with experts as well as everyday seniors on issues. We look at issues on the topic of living longer and living well. In today's Fireside Chat, we will be speaking about a very unfortunate turn of circumstances that some seniors face. That is where the power of attorney that they create to help them in their senior years turns sour, and the individuals whom they trust then take advantage of them. We're speaking about elder financial abuse, and to help us understand that topic better, we will be speaking with Leonie deGraaf Hastings of deGraaf Financial Strategies in Burlington, Ontario. Leonie is a certified financial planner and an elder planning counselor. She has been in that role for over 2 decades, and she helps clients with retirement and estate planning. She has been recognized nationally and has been named by Wealth Professional magazine as one of Canada's top 50 advisors. In fact, Leonie was ranked second on that list. deGraaf Financial Strategies itself is a family business with over 80 years of experience. Now, Leonie, when we were looking at this topic of power of attorney abuse, we came across an article in Maclean's magazine from about a decade ago, in which you were quoted, and I got the impression you were quite passionate about the issue. In the decade or so that has passed since that article came out, how have things changed? Have you seen things getting better since that time?
I would love to say that things have gotten better over the last decade, but unfortunately, with an aging demographic, that things have unfortunately gotten worse over the last decade.
That's unfortunate, truly unfortunate. Yes, and our population of 60 and over is growing. The demographic triangle is changing shape, where we're having smaller base. That's the 0 to 15, and it's no longer that pyramid.
Right.
So the pressures and the things that are going wrong in terms of elder financial abuse, we're seeing that increasing. Tell us a bit more about that. Give us an overview of elder financial abuse. Generally, what is it exactly, and how widespread is it?
Well, just in terms of general elder abuse, the World Health Organization, they define elder abuse as a single or repeated act or lack of appropriate action occurring within a relationship where there's an expectation of trust which causes harm or distress to an older person. It can be verbal, physical, psychological, or emotional, as well as sexual, financial, and even neglect, either intentional or unintentional, is considered elder abuse. So, and again, according to the World Health Organization, around 1 in 6 people aged 60 years and older experience some form of abuse in their community settings during the past year. So unfortunately, the rates of elder abuse are higher in institutions such as nursing homes and long-term care facilities. So, but the most common form of elder abuse in Canada is financial abuse. So, and financial abuse is defined as the misusing of funds or assets without the knowledge or the consent or not in the person's best interest.
Wow, that's pretty disheartening. 1 in 6. That's yes, that's something that we need to raise awareness about and let seniors know what can go wrong and how they can protect themselves in those circumstances. Now, the particular issue that we are focusing on today is power of attorney abuse. Tell us a bit about that. What exactly does that term refer to, power of attorney?
Yeah, that's a good question. A power of attorney is a document that gives power to another person to act on your behalf. So in regards to your assets or your property. And the power of attorney for property is a very powerful document. It's legally binding as soon as it's signed and properly witnessed. And so you really need to be careful, who you give that document to, who you give the power to, as well as who you give the document to. Because in Ontario, there are 2 separate power of attorney documents. One addresses your property, so it's a power of attorney for property, and that deals with all of your assets, all of your property, all of your, stuff. And the power of attorney for health is a separate document. You can have separate people, one for health and one for property, but your power of attorney for health is going to deal with any health issues, medical issues, anything such as housing, medical care, end-of-life decisions. Those sort of things are what are covered under the power of attorney for health. So I think it's really important that people know that there are 2 separate documents here in Ontario, and that they need to have both of them because they don't cross over. Just because you've named one person as your power of attorney for property doesn't automatically default that they can also make healthcare decisions for you.
Thank you very much for that. That's an important distinction to be made. And no one should feel that they automatically have to give the power of attorney for both to one individual who would have total control over their finances as well as their health decisions.
Exactly. And perhaps, people feel that there's one person who is better suited to handle the financial aspect of their lives, and perhaps another person who is better suited to deal with, more sensitive day-to-day care issues. So it's common for people to name different people, but it's also common where there aren't a lot of options, where someone would name the same person for both. But they are 2 separate documents.
Let's look more so at the power of attorney for property. If we can look a bit more at what type of property this covers and why someone would go for giving power of attorney to another individual. In what scenario is this a good thing and helpful to seniors?
I mean, we definitely want to have a power of attorney document in place, regardless of what age you are. So, the more pre-planning that you can do, typically will save some stress or heartache down the road. So, a power of attorney document is a very important and necessary document to have in place because it puts you in control of who will speak for you if you can't. And that's, even in the case of an accident or a medical emergency, which, can happen at any age. So, and if you don't have a power of attorney in place, then you really leave that to chance as to who will speak for you if you can't. So ideally, you would want to discuss with your power of attorney ahead of time what your personal wishes are in regards to how to handle your finances if you're not able to do so, or if, what measures you might want them to take in the case of a medical emergency or life-saving measures. By having this power of attorney document in place, it puts you in control by saying who you want to speak for you and having the opportunity to discuss your wishes with that person ahead of time.
That puts things in perspective. Because what you're saying, what I get from what you're saying is that a power of attorney is a document. Handing that power over to someone else is not a bad thing in itself. In fact, it is necessary, but it has to be done in the right way where you set the rules as to how your various assets are going to be handled.
Exactly. It can provide significant convenience for seniors if they do wish for their power of attorney to handle their day-to-day finances, if they become unable to do so, or if they have a diminishing capacity due to dementia or Alzheimer's or something like that. So it can certainly provide a lot of convenience to a senior, as long as the proper person is in that role.
Well, let's look at that. Let's look at what can go wrong if the person who is in that role is not the best choice. That can be a really dangerous situation that a senior can be in if you've signed a document that says, my daughter or my nephew is the one who has control over my finances. The key point, having the proper person in place that will ensure that everything goes well. But unfortunately, from the statistics that you shared with us earlier, in 1 in 6 cases, things don't go well in various forms, and there is elder financial abuse. In terms of the power of attorney, what can go wrong? How can this be really a traumatic experience for seniors if the person chosen chooses to not act in the interest of the senior?
Right. Yeah, it's, because the power of attorney document for property is so powerful, it is valid as soon as it's signed and properly witnessed. So technically, the power of attorney could take that document right away and go to the bank and start to, make decisions, withdrawals, transfers, whatever really they wish to do with the grantor's property.
When you say they can do whatever they want, what what do you mean? They can take it out, they can spend it on themselves. It's their grandma's money or your auntie's money. But if you have that power of attorney document, you can spend it on yourself. Is that what you're saying? And people do?
Well, I mean, nefarious people do. When you're granted the power of attorney, it's a fiduciary obligation, which means that the power of attorney has a fiduciary obligation and duty to the grantor to act in their best interest and to maintain accounts, really to maintain the status quo of the person that they're acting for. So they're really just supposed to be there to act on behalf of a person who is not able to act on their own. So no, they're not supposed to go in and take auntie's money, and they're not supposed to be taking grandma's money to, go to the casino or to play bingo for that week, or for whatever other reason. So, but generally, people are not deemed completely incompetent unless there is something significant, like obviously they're in a vegetative state, or there is, advancing dementia or Alzheimer's, and, it just continues to get worse and worse where, the senior doesn't understand what assets they have. They don't understand where their assets are. They don't understand the long-term consequences of their decisions. Those can all lead to incapacity. But it's very common for seniors to fade in and out of capacity even within the same day. So they could be well rested from a good night's sleep and be quite competent in the morning. But then after lunch, they start to tire out, and they may, their brain gets a little foggy in the afternoon, and, by the early evening, they're not as aware of where their assets are as they were in the morning. So that's why in general, health practitioners hesitate to name someone completely incompetent, unless there's very clear medical evidence that they are not.
The issue of capacity, mental capacity, and competence, or someone being incompetent, how does that figure into the power of attorney document and how it may be abused?
Well, as I said, that because the document is so powerful and can, be acted on immediately, without any further provisions being put inside of it, you really do need to trust the person who you're granting that access to.
There's a case that came up in your experience where that whole issue of power of attorney and declaring an individual no longer having mental capacity to control their finances, that proved how dangerous in the wrong hands a power of attorney can be. Tell us a bit more about that.
Yeah, well, the case that I talked about before was an elderly client. She was in her 80s, but she lived in her own home, and she still walked to the grocery store and to the bank a couple times a week. She was a typical 82-year-old, so she doesn't remember everything, but she could tell me clearly about how she saw Elvis at the Toronto Maple Leaf Gardens in 1957 and, share those experiences with me. So, but her son, who, really wasn't very involved with her life, lived across the country and just kind of suddenly showed up and started getting a little bossy. And my client, that kind of rubbed her the wrong way. She wasn't happy about that. And I guess he just kind of got more and more overbearing. And I guess he had his own ideas in mind that it wasn't maybe convenient for mom to live in Ontario anymore, but didn't think that she would agree to move to BC. And maybe he thought this was, a way to get her closer and easier for him to manage. I'm not sure. But rather than, her going to her own family doctor, he took her to a new doctor, and he explained to the doctor his idea of incapacity or things that he perceived to be, not just his mom not having capacity. And, things like he bought her a new couch slipcover. And she said to him, the pattern on the couch cover is a little crazy, and it's a little loud for me, and it's not my taste, it's not my style, and I can almost see wild animals in the print. And he translated that to the doctor that she's seeing things in her couch. So, it's these little small, sort of ways that they can slant things that he convinced the doctor that his mom did not have capacity. And there were caregivers that were going in once a week. And, they said, well, she did set off the smoke alarm. Who hasn't burnt toast and set off the smoke alarm? I mean, I don't think setting off a smoke alarm once in a while is something that, should cause any red flags to go off. So, but he just kind of manipulated the situation and was able to, kind of take over. He actually had her put into a mental institution or into the psychiatric ward. She was trapped there for a couple of months. I went to see her. We started to get the Office of the Public Guardian and Trustee involved to speak for her because we did suspect that there was abuse by power of attorney. And once we got her out of there, we moved her into a retirement home where she was very happy and comfortable. But then again, the son showed up and sold her house and moved her out to BC, and I was cut off from contact with her. So it's just one example of someone that I felt was very competent and did not deserve to be deemed incompetent in a blanket sense. Because, I mean, like I said, she was still going to do groceries in her own banking. She knew who the ladies at the bank were. And there really wasn't any reason for her to have, her autonomy taken away from her. So that's, kind of one of the ways that things can go awry. But, with addictions out there and, that a lot of social problems, then, oftentimes people can start to feel entitled to grandma or auntie's money.
Or mom's or dad's money. It
Yes.
can be that close a relationship, child,
It can.
parents.
It's very sad. It's very sad that you would assume that, there shouldn't be anyone on earth that you could trust more than your child. But pretty much most families are dysfunctional in one way or another. Nobody has a perfect family out there. And, things can change over the years as well. So perhaps, you had good faith by naming one child 10 years ago, but they've since developed, marital problems or, issues that can't be controlled. So,
Yes, that's an important point. When a power of attorney is made, document is drawn up, one period of your life, things can change over time. And yes, that's one reason why things can go completely in a direction that we had never hoped for or planned for. So when these documents are drawn up and they're in the hands of those that seniors hope they can trust, what are you aware of in terms of oversight? Is there any other authority or entity that can protect a senior and ensure that the holder of this power of attorney document or the person entrusted with that power is actually acting on behalf of the seniors in the seniors' best interest?
you would think because it's so powerful of a document that there would be some kind of oversight. But unfortunately, there really is no form of formal oversight over the POAs. So they have their fiduciary duty that they are supposed to act in the best interest of the grantor, but there really isn't any oversight. So it really comes down to perhaps professionals in the senior's life who, might notice some red flags. There is the Office of the Guardian, the Office of the Public Guardian and Trustee, who, if there's a problem or if you suspect abuse, that you can report it to them and they may step in and take over, but that's quite a process. And a complaint has to be made to them in order for them to look into things. They're not generally overseeing all of the power of attorneys that are out there.
So if a senior loses part of their or all of their life savings to someone who they've given power of attorney, or a boat or jewelry or any of their possessions, in your experience, is it possible to get it back, or what is the recourse for a senior who has suffered such unfortunate loss?
Unfortunately, elder abuse is very similar to any other kind of abuse in terms of the shame that's associated with it. So it's a very underreported crime, unfortunately, because of the sense of shame. And not just that, they've been taken advantage of, but another layer that it's been from someone that they trust. So they are really skeptical to report or to try and bring in some outside help to deal with the situation. So the police have certainly gotten involved in cases. If you feel that, you have been subject to theft by power of attorney or some kind of elder financial abuse, you can certainly call the police. They would be more than willing to come and investigate and take the details. And judges certainly do not look favorably on those people that come in front of them and, were given this fiduciary duty to act in their parents' best interest, and they don't. So the judges do not see those perpetrators in a favorable light when they do end up in front of them.
I can also imagine, in addition to the shame that a senior may face, having been the victim of elder financial abuse, power of attorney abuse, there may also be a reluctance to get a family member into trouble, even though that person has harmed them, hurt them. That also results in the underreporting. Exactly.
It's very difficult for them to admit that, they at one point trusted this person, and this trust has now been broken, and not just that the trust is broken, but now that they're a victim as well. And, similar to domestic violence, there's that shame aspect there, and thinking that somehow the senior contributed to facilitating this. So it's really tough for them to admit it, to accept that, a family member or someone that they once trusted implicitly would turn around and in some cases, liquidate assets and leave them destitute. And in terms of recourse on that, oftentimes the money is spent. So there oftentimes is no recourse. If it's a gambling addiction or a drug or alcohol addiction, that money is long gone. It was, to get the fix of the day. And, so to try and recover that is difficult.
Let's say a senior comes to you and is one of your clients, is looking to get that power of attorney document to give power to someone else. what would you recommend a senior do to not get into that difficult situation in the first place? How would you recommend a senior go about protecting him or herself?
Well, some steps that can be taken to protect oneself from power of attorney abuse is to write in your power of attorney document that your incapacity is only to be determined by either your own family doctor or an independent capacity assessor. Not just any doctor that, the POA takes the senior to. So your own family doctor has your own family doctor has known you for a long time, and you see my doggy in the background there. Sorry about that.
No, no, no. He's quite welcome. He's quite welcome to join us in the chat.
They're behaving for the moment. So, um, so yes, ideally someone who knows you, has known you for a long time, would be able to pick up on signs of your diminishing capacity and, could confirm that because they personally know you. Um, so, and, professionals should have a level of responsibility there to watch out for red flags that, if we see that the power of attorney is doing things that are out of character for the person they're supposed to be acting for, if there's suddenly withdrawals coming out of accounts that are unusual or not within the norm, those are some of the red flags. But I think putting it in the document itself, who you wish to have your capacity determined by, is probably one of the biggest layers of protection that you could add in there.
That would ensure that not just anybody will say, based on the person holding the power of attorney, that mom or auntie is no longer in control of his or her faculties, and therefore all control of the assets goes to this individual to manage as he or she decides, and the senior has no control whatsoever anymore. That's the recommendation. The final area I wanted to look at to ensure that you don't go into these complications. What would you recommend to a client in terms of what to look for as the individual to put this trust, to place this trust in? What are good indicators that a power of attorney arrangement should run smoothly and not lead a senior into this very dangerous territory?
Right. Well, as I mentioned, most families do have some level of dysfunction. So to kind of take a step back, take a look at the family dynamics. You know how your children interact with each other. Are there two that get along and two that don't? Do they all get along? Do none of them get along? First, taking a look at those family dynamics and thinking out the long-term ramifications of, who you are going to name as your power of attorney, and deciding if one person is more capable of being your power of attorney for finance and one is more appropriate for health. But in terms of, family dynamics aside, you would want to be looking for someone who is, in general, a responsible person, a responsible, caring person, someone who pays their bills and their taxes on time. So someone who, they're not looking at the inheritance as necessarily, a windfall or the solution to all of their problems. If you know that, there's an addiction problem with someone, then that's probably the last person that you may want to name as the power of attorney, just because other influences are at play. And, at some point life can get desperate and they may be tempted to act nefariously rather than in your best interest. So just generally a responsible type of a person who is aware, is relatively intelligent, does their own banking, that sort of thing. So just looking for those kind of qualities in a power of attorney, and taking the family dynamics into consideration.
Those were the areas I had to cover. Were there any other aspects of this issue that you feel it's important that we have not touched on yet, that seniors should think about when considering putting this sort of trust in someone as they age?
I don't want to scare people away from having a power of attorney. So, because as I mentioned, it's a very important document. It can, address a lot of issues in the future that, you may not be able to. But some layers of protection that could be added in. If you're a little concerned, that one child may or may not, act appropriately, you could name two kids as your power of attorney, and you can name them jointly, so that, it's not just one person making the decision, it's two. If you're really concerned that, two of your kids, they just do nothing but fight, they've never gotten along and they never will, perhaps adding in a lawyer as a third power of attorney, as the tiebreaker. That might be, or a trusted friend of yours to be the tiebreaker. It's very common for people to name their children as their POA, but it's not required. It's not necessary. If you have a family friend that you trust almost as much, sometimes maybe even more, ideally someone that's younger than you are, to serve in that position as either a tiebreaker or the power of attorney themselves. So it is a big responsibility, having to take over the finances for another adult. So, you want to make sure that the person that you name would take that, that duty with care and responsibility, and would pay attention the way that you would expect them to. So, and I think just making sure that it is in place. You don't have to give it out. It can be signed and witnessed and kept in your possession until, an accident happens or something like that, where it invokes, the need for the power of attorney. So you could keep it in a safety deposit box if you tell your power of attorney where they can find it, if they need it, or that someone knows where it is. You can also carry a little card in your wallet that states who your power of attorney is and their contact information, so that if you are in an accident or you're found, unconscious or something like that, that health professionals or emergency professionals are trained to, look in your wallet for an indication of who might be, your power of attorney to make decisions for you. So, and lastly, I caution people to sign the power of attorney at the bank. So I've known of people that have gone into the bank and they say, I'd like my daughter to, have access to my account because I'm going to go to Florida for the winter, or I have a surgery coming up and I don't know that I can, get to my banking. I would like, my daughter to have access. And in the past, they have presented that person with the bank's own power of attorney document that they want to keep on file. However, this negates any past power of attorney document that they had set in place, and this now sets the new precedent. So there's no reason that you should be signing anybody's power of attorney document because that's their corporate policy. You should be able to bring in your own properly executed power of attorney document, allow them to take a copy of it to hold on file that they can reference in the future. But I would just caution anybody from signing, what someone says is the corporate policy that, we need our own document on file here. So you just don't want to negate anything that you've already put in place.
That's well noted, that seniors should not just be swayed by what the person on the other side of the desk at the bank is saying. This is how we do it, so sign here.
Exactly. There's a lot of legal ramifications there, and I'm sure it's not intended, but it does have consequences. So there's a reason why we do retirement planning and estate planning, is to put these things in place now while the person is competent. We can foresee what some of the long-term ramifications would be, and so to have those plans disrupted at some point in the future, kind of goes against what we've been planning for.
Just a note on that retirement planning and putting in the power of attorney in place. You work with clients. How early in retirement or before retirement would you say seniors or near seniors should be looking at planning, including planning for power of attorney?
I'm an advocate that once you're an adult, you have to start putting these things in place. So really anyone of any age, anything can happen. We could all, have the misfortune of being in an accident or something like that, and not being able to speak for ourselves. So starting as early as possible to put those documents in place, and to have, sort of a system to revisit that every few years. So whether that's every 2 to 3 to 5 years that you revisit those documents, your will, your power of attorney, and your executor, making sure that that's all still how you wish it to be. Just keeping on top of things like that. So any major life events, marriages, births, deaths, can tend to, need to make changes on those documents. So, and power of attorney abuse tends to be highest after the death of a spouse. Just to be mindful of that phase of life as well, that once you're on your own, that the risk is going to increase. So it's prudent to revisit things at that time as well.
That's solid advice. Thank you so much, Leonie. Thank you very much for all that you have shared with us, so that we could understand fully this issue of elder financial abuse in general, and specifically power of attorney abuse. Thank you so much for your time and the valuable information you have shared.
Thank you very much for having me. It's been a pleasure.
So I'd like to say a very special thank you to our guest today, Leonie deGraaf Hastings, for giving us an overview of this issue, that very crucial and unfortunate situation where the power of attorney does not work out as seniors had hoped. Yes, elder financial abuse, that is an issue that we need to be looking at and be aware of what can happen and how we can avoid those dangers. I am Celia Sanka, Executive Director of the DiversityCanada Foundation, and this has been another episode in the Golden Years Fireside Chat. Drop by at goldenvoices.com to see more in the series of the Golden Years Fireside Chats, and to connect with seniors to focus on issues of importance to seniors. Take care and see you sometime soon. Bye for now.